Hi, good afternoon, everybody. Welcome to the London International Disputes Week graveyard shift, which has meant that they've kept the best to last. This afternoon's panellists will be discussing construction disputes in a post-COVID world. My name is Gerry Brannigan. I'm a partner and head of forensic technical services at HKA. So first of all, I'll be moderating, so a little bit of housekeeping. The session is being recorded, which will be available to all attendees afterwards, and I understand it will come out by email. Everyone is on mute, so please put your questions in the question box. And if we don't get a chance to answer all of your questions today, we'll do a follow-up email over the course of the next week. So thanks in advance for sending us some questions. Lastly, at the end of the session, there's going to be a questionnaire. It'd be great if you could complete that, and that'll help identify any additional requirements for the next sessions, or whether you want to be kept up to date with future events. So first of all, I'd like to introduce you to today's panel. Kate Corby is going to be talking about the impact on the resolution of existing construction disputes. Kate is a partner in Baker McKenzie's dispute resolution team in London. Kate has substantial experience of representing clients in complex litigation and arbitration, with a focus on construction and engineering disputes. She's got significant experience in advising in product liability, safety and regulatory compliance, and she acts for employers, main contractors, subcontractors and joint venture partners from across the world on disputes concerning issues such as project delays, cost overruns and defective work. Helen Collie is going to be discussing about the changes due to COVID which are going to take place in the future of construction disputes and how that is going to look. Helen is a technical director with HKA. She's a chartered structural engineer with 15 years of construction industry experience and a master's in construction law and dispute resolution. She's been appointed as technical expert on multiple occasions and has a background in design and coordination of arts, education, healthcare and commercial structures. Her experience spans the commercial building design arena, from high-rise concrete structures in the Middle East to adaptive reuse of existing London building stock, all the way through to complex steelwork arrangements. So, David Nitek, is going to be discussing how COVID will influence future construction disputes. And David is a partner in Herbert Freehills, based in London, and specialises in the resolution of infrastructure, construction and engineering disputes. His vast experience advising on disputes involving litigation, arbitration and other forms of alternative dispute resolution, including adjudication and dispute boards. Much of his practice comprises helping clients to establish robust processes for resolving claims without the need for formal proceedings. David helps clients, including international employers, contractors, subcontractors and consultants in a variety of sectors, including transport and energy. And last but not least, Amy Armitage is going to be showing us the ways of mitigating future construction-related COVID disputes. Amy is a dispute resolution lawyer from Norton Fulbright in London. Her practice encompasses disputes management as well as dispute resolution in the context of construction and engineering disputes in the infrastructure and energy sectors, and as well as the built environment. She's experienced in all forms of dispute resolution, including high court litigation, international arbitration, adjudication and mediation. And she's got a full range of construction project clients, including contractors, subcontractors, employers, insurers, and funders. And our clients are based across Europe, Africa, and the Middle East. So thank you very much for all of our panelists today, and I will pass over to Kate to start. Thanks very much.
Thanks for the introduction, Gerry, and delighted to be here with you all today. I hope you've all found LIDW21 as interesting as I have so far. As Gerry mentioned, I'm going to kick off the substantive part of the session by talking for a few minutes about the post-COVID world of construction, not about the post-COVID world of construction disputes, but about the impact the pandemic has already had on construction disputes as we start to emerge, in some parts of the world at least, from the depths of the pandemic. There's three subtopics I'm going to cover here. Firstly, the impact the pandemic has had on the way in which we resolve construction disputes, which have already reached the stage of formal proceedings. As with many aspects of working life, I think it's probably not an understatement to say that very significant changes have occurred, which will have a lasting future impact. And by that, I'm referring to the move to virtual hearings and mediations. For many years now, courts and tribunals have flirted with becoming more online and tech savvy, but change has been very slow in coming. However, the saying, necessity is the mother of invention, is most definitely true in this context. We've now been fully up and running in a world of virtual hearings and mediations for over a year. Of course, many advantages of the virtual world. One which springs to mind is the travel costs for hearings, particularly high-value international construction cases, should not be underestimated. And by doing them virtually, they are all but negated. With no need for everybody to be in the same country or location within the same country, there's greater availability because you don't need to factor in travel time. Although, that being said, time zones can make it quite challenging. And as I said, it has incentivized developments in technology that we've been waiting and wanting for quite some time. On the other hand, of course, technology is great when it works, not so great when it doesn't work. And that was, I think, one of the main concerns people had about going to doing more aspects of hearings online in the first place. There's the Zoom fatigue. We all know, I think, that it's harder to concentrate for as long when you're looking at screens. There's the issue of conversations being inadvertently hurt by the opposing side when you forget to mute. And we've all seen some high-profile examples of those in the legal press. Confidentiality concerns, cybersecurity is also something to bear in mind. But I think probably at the heart of the previous reluctance to move to having more virtual hearings is concerns around effectiveness. So some people are of a view that it's more difficult for judges or arbitrators to test the veracity of the evidence, assess witness credibility, more difficult to cross-examine witnesses when you're not there in the room with them. It's certainly harder for counsel and client teams or the arbitral tribunal to confer with each other when they're not there in person. And for mediations, I think in many senses, the human connection is so important to being able to reach a deal on the day, and being all down the computer screen from each other can make you feel a bit more distant. Do I think virtual hearings and mediations are here to stay? I'd say probably, like many of the changes to working culture brought on by the pandemic, they are in some form and to some degree. There's definitely support in the UK at the highest level within the English court system. But interestingly, in recent days, the UK's bar councils have recently released a joint statement in which they've said that virtual hearings have multiple and multifaceted disadvantages, to quote them, compared with in-person proceedings. And the commercial court, at least, has recently announced that it expects to return to in-person trials, or mostly in-person, as they describe them, after lockdown restrictions are lifted. But Fridays, when applications tend to be heard, will remain virtual for now. Interestingly, they've also said that e-bundles should be the default going forwards. So that's certainly one development that looks like it's going to stick around. I'd say generally there's overall more skepticism about trials and full hearings working well remotely than interim applications. And having been involved in both types of hearings done virtually over the last year, I would say I'm very much a convert. They went far better than I ever expected they would. At Baker McKenzie, we ran a survey earlier this year with KPMG about virtual hearings and mediations. I thought it worth flagging some of the key results which may or may not resonate with your own experiences. So one question we asked was in relation to the next civil dispute that you're involved in. If either option is available, would you prefer a virtual hearing or an in-person hearing? Interestingly, for an interim hearing, almost 70% of respondents said they would prefer a virtual hearing, and only 10% said that they would want a hearing in person. On the flip side, for a final hearing or trial, about 48% said that they would want it to be in person. But interestingly, 35% said they wanted a combination of in-person and virtual. When it comes to mediations, I thought it was very interesting that while 80% found that their virtual mediation experience was good or better, less than 20% thought it was as effective as doing it in person. So as with many of the changes that we're seeing throughout our lives from the pandemic, if I had to place a bet, I would say we're going to end up with a hybrid model to a greater or lesser degree, depending on the key factors in the case, in particular the type of hearing, the issues, the complexity of the issues, the proportionality of the cost of meeting in person, and availability. The second area I wanted to talk about was what sort of construction-related disputes have been caused by the pandemic in tangible ways that we've seen already, and what do they tell us about resolving construction disputes? So during the first wave, back in the spring of 2020, as a firm, we were seeing lots of urgent issues coming up related to the ability to make claims for force majeure or changes in law. We saw an uptick in the type of work I'd describe as acting as project counsel, by which I mean helping clients in ongoing projects to reach an early resolution of disputes, whether it's assisting with preparation of FM notices or assisting with responding to them. We saw this right across the world. So I was involved in them in projects in the Maldives, Uzbekistan, the Middle East, and the UK. They were all with similar issues. So what did I take away from those instances, and what might that tell us about the kind of things that are going to come up in the future when these disputes wind their way to being formal disputes? First is always remember to check the exact wording of the contract. Governing law, which can have a big impact on the topic. What does the force majeure provision actually say about foreseeability, impossibility, and often crucially mitigation, because they're not all the same. Then you need to apply the clause to the specific facts, gathering the necessary evidence. For example, is there a government order about the movement of people or materials? What impact did that actually have? And how did the FM event cause it? And what evidence is there to back that up? What must you make sure that you do about mitigation, for example, using local labour or locally sourced materials instead? And that's where I think there's going to be a lot of room for debate when some of these disputes wind their way through to arbitration or litigation. Also beware of notice requirements, as tedious as they can be, that they are important. And then finally, we spent a lot of time talking to clients about what were they actually trying to achieve. So was it protection from LDs, or did they actually want to terminate? Was this a good way to try to get out of the contract? Or actually, is what they want a renegotiation of the commercial terms, and therefore perhaps sending a formal FM notice might not be the best thing in their interests. In line with what we were seeing in more mainstream commercial work, I would say the overall trend was for parties to try to work together through the issues to find a practical pathway through the problem that was in the best interests of both sides, as well as the project itself. Inevitably, some of those issues will end up in formal DR proceedings, but many will not. In many cases, particularly for larger, lengthier projects, delays caused by the pandemic will just be one of multiple events being relied upon to claim extensions of time and increased costs, which will stand or fall just like any other cause, compliance with the contractual terms, evidence, etc. Post wave 1 and into wave 2, and now as we hopefully emerge into a post-COVID era, it's harder to argue that the impacts of the pandemic are not foreseeable or unable to be mitigated against, given all the experiences and learnings of the last year or so. But in my experience, parties are being less tolerant about trying to work out a solution together. Insolvencies in the contractual chain are increasing, and that's causing obvious added difficulties. And so finally, over 14 months into the pandemic, where are we now in respect of these disputes which have already been caused? In some senses, I think it's still too early to tell. While we all have anecdotal views, we're still too early, even in this calendar year, to see the sort of global reports that give a statistical picture, like the ICC and LCIA annual reports, the Arcadis annual construction disputes review. It's even too early, I think, in the dispute cycle for HK's Crux dashboard to give us that much information about whether we're seeing an uptick in these disputes. One area I would highlight here is mediation. I'd say that we're definitely seeing an increase in the number of cases in which mediation is at least being attempted. Certainly when you inquire about the availability of mediators to help with disputes that have already arisen, availability seems to be quite thin on the ground. They're very in demand at the moment. I think it's also safe to say that for many projects which have suffered due to the pandemic, the formalisation of those disputes is still to come. It'll be interesting to see at LIDW next year whether there has been a tsunami of construction claims by then or not. Back to you, Gerry.
That's great, Kate. Thanks very much. And I would pass on now to Helen.
Thanks very much, Gerry, and thank you also, Kate, for a really interesting insight into the changes already impacting construction disputes. I got quite a fun job here. I got to look into a crystal ball a bit further into the future and look at how things might change fairly long term. So when this topic was first put to me, that's as a structural engineer dealing mainly with disputes around design and workmanship, my initial thoughts were that COVID was unlikely to change my daily work. I could see that proportion of the causes of disputes might change. So there might be supply chain, payment, labour shortage issues, and they could possibly become more prevalent. But I hadn't really thought about the substance of the disputes changing, which is a really interesting topic, and it leads us to look at the question, will COVID affect the broader nature of construction going forward? I think the obvious answer is a resounding yes. COVID has and will probably continue to have a lasting impact on the construction industry, from the supply chain right through to the end use of its products, as it were, how those are viewed and utilised by people. And as a result, I feel fairly certain that this will impact the subject of disputes that we see. I've chosen 3 broad categories to do my whistle-stop tour of future predictions. And those are the way that we as an industry work in construction, the type of projects being procured and built, and attitudes towards climate change, which might not seem an obvious COVID effect, but I think it's worth including, actually. So in terms of the way we're working, like every industry, and we're here today all remotely, at least some functions of construction have been forced remote. That carries with it challenges as well as opportunities. Design teams that previously could gather in a room to work through coordination and design issues haven't been able to do that. I see the potential for that to have an effect on both the design construction process and the end product. So, for example, will the quality of work being produced have fallen? We may see disputes arising more out of poor coordination or late design changes due to less thorough design. It remains to be seen whether the impacts of fractured design teams, whether we see impacts on quality on site and in the finished product. But I definitely see potential for disputes over gaps in communication throughout the design and construction process. As probably with every talk on COVID, turning to tech, trying to imagine living through this pandemic without technology is fairly mind-boggling for me. The construction industry is renowned for being slow to catch up to emerging technology. I'll quote the former CEO of Multiplex saying, from a digital and innovation point of view, construction is just one step ahead of farming, which is a fairly damning review of his own industry. COVID has, to a certain extent, I think, forced the industry's hand, and Kate touched on this, of accelerating the uptake of technology. Building Magazine called it a catalyst for the digitalization of construction, which I think is probably fair. And there's been much greater, wider and faster adoption, including digital project management, BIM, and field-based tools. But in construction terms, that was almost an overnight change. Was everybody ready? I mean, my view is that this could very well lead to disputes over poor use of BIM, for example, and is a drone survey or a virtual safety briefing actually any substitute for real site knowledge? You know, my view of having investigated things remotely is that there's maybe nothing quite the same as visiting site yourself and interacting with other people. So moving on to project types, I'm just going to touch on a few ideas here because obviously it's a huge topic. It seems obvious that the way we work and move around as a society will change, and as a result the things we build might change and how we build them too. So that said, it seems the predicted downturn in commercial offices hasn't happened. I think I read today there are 310 skyscrapers with planning permission in London for the next decade or so, which is incredible. But sadly, there has been a downturn in hospitality, retail and entertainment. I wonder if we might see an increase in repurposing buildings and the disputes associated with retrofit. We see a lot of this, unforeseen building conditions and who carries that risk. And then just another one that springs to mind immediately is our healthcare needs having changed. So higher specifications and more flexibility seem likely. I'm not a hospital architect, but I imagine these types of things are being talked about. The engineering design for healthcare is incredibly specific. They can demand much higher tolerances, specialist equipment, and exceptional design life criteria, for example. All of these we've seen form the basis of disputes, and I think we may see them rise as the needs do. And finally, for the latest trend in construction, COVID really has been a boon, and that's off-site construction. It was already a hot topic, and it seems to have been accelerated. I imagine because less reliance on site labour is a huge advantage at the moment. The types and particularly magnitudes of disputes, I think, that could arise out of that are quite interesting to consider. And then finally, moving on to climate change, and perhaps off-site construction is related, because I think traditional materials have really come under fire as climate change has risen up the agenda. It was already a hot topic and a key focus of many engineering practices, but it seems to have been accelerated. I wonder if that's perhaps because of an increased awareness or respect for scientific experts rather than policymakers, but also maybe because building infrastructure has been identified as a key part of COVID recovery, and its focus might be slightly different. I think sustainability and resilience are real keywords looking forward. Also related to both infrastructure and climate change is the fact that business travel is predicted to change dramatically. Again, I read today, I think Bill Gates predicted that it would reduce by 50%. I mean, I don't know where his data comes from, but certainly I can see the case for it reducing. So the opportunity presented by investment in recovery is ideal for climate change to be at the heart of significant construction projects and part of the green economic recovery for the government. I wonder if it will bring whole new categories of dispute, actually, for example, surrounding carbon reduction targets and whether they're met. How do you measure that? What are the parameters that you're looking at? And in terms of, I'm thinking specifically in terms of structural design, but probably applies across the engineering spectrum, is efficiency is bound to be very key. So as a structural engineer, I've seen a lot of discourse recently about reducing the loads in design, for example, to push building efficiency further and therefore green those structures. Similarly, using innovative materials in new ways, timber being a prime example. But whenever safety factors are eroded, for example, in the load application example, inevitably the potential for something to go wrong increases, and state-of-the-art type projects might attract state-of-the-art type disputes, and it might be that climate change drives that in the future. And finally, I wonder if we might see disputes over buildings not being designed as sustainably as they could be. Possibly a question for the lawyers in the room, but could sustainability terms be written into contracts? Do we have enough knowledge to do that, to impose new regimes of parameters on our designers? We've already actually seen hints of these kind of disputes relating to efficiency design, but as client awareness of the issue rises, I'd expect them to also increase. So, as I said, a very brief whistle-stop tour, but I've quite enjoyed having a look into my crystal ball to have some predictions about the future. I think construction has shown itself to be very resilient, actually, and remarkably adaptable, in particular getting to grips with innovative technology much faster than might have been predicted. That adaptability has led to changes, which some of which I've described, hopefully, and which will undoubtedly affect the character of disputes that we see arising out of projects. All of that said, I think it's probably going to be some time before we see the proportions of dispute causes changing and the broad nature of disputes changing significantly. I think in the short and medium term, it's more likely to be things like delay and supply chain and payment issues, which my other panelists have and I think we'll go on to touch on. So. Thank you very much, and back to you, Gerry.
That was fantastic, Helen. Really interesting. Thank you very much. At this stage, before I introduce the next speaker, can I remind everybody, we've got a few questions in so far, but if Anybody has got a question for any of the panelists, please put it in the question box, and we will cover that at the end of the 4 talks. Thanks very much. And at that stage, I'll pass over to David. Thank you.
Thanks, Gerry, and hello, everyone. It's a pleasure to be with you for this final session of LIDW. So I'm going to spend a few minutes talking about how COVID is going to influence future construction claims. So in some respects, it's the other half of how Kate kicked off this session. And I'm going to split it into 2 parts. The first is to look at how COVID will affect the number and type of construction disputes that we have going forward. And the second is to look at some of the themes that Kate touched on earlier around the process and how it's going to influence the way in which procedurally construction disputes are resolved in the future. In terms of the substance, I think I'll say slightly more on this first part than on the procedure, because Kate's already covered that very well. The first thing I would say is that many COVID disputes haven't yet been resolved, even stretching back to disputes that first arose and were first notified in March and April last year when the lockdown happened. And it may be that that's because in many cases, I think the parties were initially at least working collaboratively together, and they were agreeing short-term fixes, perhaps by way of a COVID-related standstill agreement, or there may have been temporary relaxations of payment regimes just to get everybody through the immediate bite of the lockdown. But fundamentally, I think there are a number of projects where the big questions as to who bears the risk and to what extent has COVID delayed that project, that remains unanswered. And I think those disputes are going to be particularly difficult to assess because, well, 2 reasons really. I think the first is that any productivity claim, as the experts on the call will know, is going to be difficult. You're very heavily reliant on the quality of your records, both as to the level of productivity that was planned and the level of productivity that was in fact achieved. Those records often don't exist as you would want them. But the related point is that the longer you leave these disputes to before you start to grapple with those sorts of issues, the more intractable they become, because records are more difficult to get hold of. The people that you need to speak to have moved on. It becomes more challenging to try to unpick the impact of COVID and non-COVID impacts on the project. So I think there are a number of very significant, very complex COVID disputes that haven't yet been resolved, and I think that's going to be a recurring theme for some time yet. The other related point I'd make is that I think COVID is also, in a construction context, going to give rise to more non-COVID claims, which sounds like an odd thing to say, but I think one thing that COVID did have on all projects was some form of economic impact, and it would have been greater in some cases and lesser in others. But even if you're on a project where all COVID claims have been resolved, that will have had an economic impact. It will have eaten into margins, it will have eaten into contingencies. And as a result, you have a project which is less able to cope with future financial shocks. So to put it very simply, if a project is in economic distress or economic difficulties, its claims are more likely. And while nobody ever wants to end up in dispute to resolve those claims, if the contingencies are gone and the margins are gone, then sometimes it is the only option. So I think even on those projects which have managed to get through COVID without there being a formal dispute and to have put the COVID claims behind them by some form of settlement, I think there is still the potential for the financial impact of that settlement to give rise to other claims further down the line. Third point I'd make is on material shortages and price increases, and that's something I've just in the last couple of weeks started to advise clients on, and in particular I think steel is the sort of hot topic at the moment. The price of steel is at an all-time high, and that's driven in part I think by the level of demand in countries like China going up after a bit of a lull over the pandemic. They're starting to build again, and that's given rise to a surge in demand. I also think in the case of steel there have been curbs on production, as I understand it, which have contributed to that price rise. But I think what it illustrates is that when the big economies do start to recover, when they start to use infrastructure spending as a way to address some of the economic impact of COVID, you have the potential for the market in some commodities, raw materials, to get extremely hot. So we've got an infrastructure bill in the US, which presumably will be passed in some form. Whether it's as wide-ranging as currently proposed, who knows? But it's likely to be passed in some form. We're going to build back better in the UK. So there is the potential, I think, for a lot of projects to start coming online at once, combined with a resurgence in all of those projects that were put on hold during the first lockdown. And all of that, it leads to a perfect storm, if you like, for increased material costs. And that's inevitably going to give rise to a question of who bears the risk of that price escalation under the contract. If you're in a civil law jurisdiction, there may be provisions of the civil code that you can look to rely on, for example, if there's relief, some form of relief from undue economic hardship. So it will give rise to, I think, to those sorts of questions, but also going back to where I started, it puts economic pressure on the project. When that happens, you have a greater likelihood of there being disputes further down the line. Fourth one I will mention is insolvency, which I think unfortunately could be a feature of the landscape, obviously not just in construction, but more broadly going forward. Construction was one of the sectors that was able to carry on, and we had the letter from the Secretary of State confirming that relatively early in the pandemic. But of course, there was an increase in inefficient working, and that does have a financial impact. The figure that really interested me was that apparently in 2020 there were insolvencies in the construction sector were 40% down on where they were in 2019, so pre-pandemic. I don't think that's because firms have suddenly started defying the rules of economic gravity. I think it's because there was a suspension of these rules during the pandemic, particularly early on. So you had deferred rent, deferred VAT, payment relief, and so on. But that doesn't fix the problem. That potentially just stores up the problem. So much like after the last financial crisis, there was much talk of zombie companies who weren't viable, and it was just a question of when, not if, they would become insolvent. That may be something that we start to see, sadly, in the construction sector, particularly as furlough schemes end and loans which have been taken out thus far need to be repaid. So insolvency, again, something that is always has a negative impact on a project when a key player becomes insolvent. I just wanted to, on that note, pick up on a recent development from a couple of days ago, which was something you may have read about on the Virgin Active restructuring plan. So there was a change in the insolvency rules last year in the Insolvency and Governance Act 2020, which introduced a new restructuring process called a restructuring plan. It's a bit like, as I understand it, being a non-insolvency lawyer, a sort of Chapter 11 style bankruptcy procedure that allows a company to restructure, but to carry on as a going concern, and the managers and the shareholders stay in place. And there has been a bit of talk after the Virgin Active decision, which effectively affirmed the company's entitlement in that case to implement a restructuring plan, that this may be a route for companies which are not approaching insolvency, but in some form of economic difficulty, to try to restructure their way out of particularly unsecured claims that are being made against them. So I think that is something that could potentially feature quite heavily, not just in construction, but much more widely. Companies looking to use this new restructuring plan route as a way of restructuring debts, avoiding having to litigate claims, particularly unsecured claims, but not having to enter into a formal insolvency process such as liquidation or administration. I'll touch very briefly on modular construction. I think this picks up a few of the themes that Helen was talking, and that was something that I was reading a lot about right at the start of the pandemic, because modular construction makes socially distanced working easier. You can reduce your presence on site, and when you're building the module in its factory setting, you've got a greater control over social distancing. A couple of experiences that I've had, not recently, but with modular construction more generally, which may again be a feature of the landscape going forward if it is something that becomes more common over time, is that if the modularise and it works, it's great. If the modularise at site and it doesn't work, and this is particularly an issue in complex projects, then you have potentially a big problem, because your program is likely to assume it does work or works with relatively limited tinkering. What you need is a complete rebuild. If that module isn't right, you've suddenly lost your program. And again, that has given rise to a couple of disputes I've worked on in the past. I think if we're going to see more modular construction, I would expect to see those sorts of issues occurring again going forward. just conscious of the time, I'm going to largely skip over remote hearings, as I say, because Kate covered it so well. I did just want to touch very briefly on green arbitration, which is something I've been reading about quite a bit. I don't know how much we'll be seeing it going forward, but it is in many ways the corollary of what everyone was doing during the lockdown. The way in which hearings were conducted, trials were conducted, cases were conducted during lockdown was green. There was no air travel, hearings were virtual, trials were largely paperless. And that, I think, has given rise to a couple of precedent green arbitration clauses, which I've seen. I'm not sure whether or how quickly they'll be making their way into construction contracts, but looking really, I think, to lock in the environmental savings that we've all learned during the pandemic that we can deal with. My personal view, I think, really echoes Kate's, which is that if you're looking at any sort of substantive complex hearing, a virtual hearing is definitely second best. There is no substitute in that case for a traditional face-to-face hearing. And Kate referred to the Bar Council's feedback, which described it as a virtual hearing is a markedly inferior experience. But on the other hand, it is horses for courses. And I think procedural hearings, simple hearings, I think the parties are probably more likely to go down a virtual route for those hearings now than they would pre-pandemic. And that plays into this sort of green arbitration concept. I also think there's going to be more of a move to paperless hearings. I think that had already happened, but the pandemic and one of its few upsides is I think it accelerated the embrace of technology by Luddites like myself in the legal profession. So I think that will become more common. I must say I'm sceptical that some of the full-blown green arbitration provisions that I've seen, which require parties to submit statements at the outset of the arbitration explaining how they're going to strive towards carbon zero, I'm sort of sceptical that those sorts of provisions will ever really take hold. But I think what the pandemic has done is show us that there is a greener, if not fully green, way of bringing, fighting, defending international arbitration, international construction disputes. On which note, Gerry, I will pass back to you. Thank you.
Great, thanks very much, David. Once again, just last chance, next 10 minutes to put in a question. We've got a couple already. Anybody has anything for any of the panelists, please just let us know in the chat, the question box, please. So finally, pass over to Amy for the last section. Thanks very much.
Thanks, Gerry. I was just going to briefly speak about some of the drafting changes that we've seen being implemented in response to the pandemic, and just some practical measures really that parties can adopt in order to try and mitigate COVID disputes in the future. I think one thing that the pandemic has definitely highlighted is that the standard form contracts that we're all familiar with weren't really designed to deal with the kind of extreme circumstances that we've all experienced over the past 12 months. And the availability of relief for COVID-related impact has really varied between the standard forms, and given that the forms themselves are routinely amended, I think from my perspective it's been a bit of a mixed bag in terms of what the parties may be entitled to recover in any given project. So looking forward, I think there's a real opportunity for those parties entering into contracts now to really future-proof those contracts by expressly allocating specific risks of COVID-19 associated delay and increased costs between them, and therefore hopefully avoiding future disputes arising. The parties that we've been advising are generally looking to achieve clarity around what is foreseen, what has been priced for, as well as visibility around the likely impact if the rules are changed again. Essentially distinguishing between the foreseeability of the pandemic itself and foreseeability in relation to its progress and future impact on the workforce and supply chain. Generally speaking, we've seen employers looking to restrict claims for generic things such as the global economic downturn, market price movements, labour shortages and supplier insolvencies. I think there's also an expectation by now that contractors should have a pretty decent handle on the impact of COVID restrictions on the programme and the price, and should accept the risk of managing the known site restrictions, at least for a limited period. From the contractor's point of view, very nervous about taking unlimited COVID risk on a project They want to address the increased costs of performance, make sure they're compensated, where there have been changes to their methods of working, where there may be delays to the delivery of goods to the site due to international restrictions. So we've seen a range of sort of risk sharing arrangements in response to COVID, which have included things like contractors accepting COVID risk on the project for an initial period, maybe the first 6 months, and then receiving greater time and relief cost as well at the end of the project. Specific relief for COVID changes in law, so where the parties have bypassed the kind of pre-pandemic very narrow definition of law, expanding it so that it specifically includes things like government guidance, government decisions, the SOPs. We've also seen amendments that require the change in law clause to impact specific requirements of the works, so may capture things like the shortage in supply, site closures, delays in availability of materials, etc. Or it may require cost relief to be attached to delay, so not just because PPEs become more expensive, for example. And in some cases, the parties have expressly agreed that the existence of the pandemic itself at the time of signing the contract does not make the consequences foreseeable for the purpose of the definition of the relief events. Parties have also signed up to a COVID-19 protocol, which sets out the measures that the contractor has undertaken to deal with the current COVID restrictions, and then the contractor then commits to this in the construction programme and the price. The parties agree that any time or cost relief is subject to the contract having implemented the COVID-19 protocol. Some drafting considerations we've had to think about in relation to these issues include things like, how do you define the COVID-19 event? Does it include future strains, mutations, outbreaks? Does there need to be a declaration from the WHO or a public health authority of pandemic? Making sure that you've clearly specified the exact circumstances that will give rise to the relief. So identifying the particular trigger event in each case and what form of relief that gives rise to. So where there's a tightening of government restrictions, for example, or delay in the availability of materials, does this give rise to a right to additional time? Is it also a right to costs? And is this limited to specific categories of costs? Importantly, what causation test do you include? Does the required impact of the COVID event need to prevent or hinder or affect or delay performance? And parties need to give this quite a bit of thought, because depending on the wording of the clause, it may be that a party will be denied relief on the basis that it wasn't actually ready to and willing and able to perform the works in any event. The duty to mitigate is important. What does this actually entail? Because again, depending upon the wording of the clause, there may be reasonable steps that the party could have taken to avoid or mitigate the effects of COVID-19. And if they fail to do this, then this could preclude relief. So I think if the parties properly explore all of these things and agree the approach in advance, that this will go quite some way towards avoiding COVID disputes in the future. But for those parties already in dispute, what can be done to mitigate the risks and avoid costly court or arbitration proceedings? I think it's very obvious, but it's still worth saying that parties should always try to collaborate as far as possible and really try to exhaust every angle they can before commencing formal proceedings. Most contracts will contain dispute escalation provisions, which typically consist of consultation or negotiation and at possibly different seniority levels within the companies. There may be an express duty to consult or negotiate in good faith. I think it's always worth going through each step, and in some cases the steps may be mandatory, in which case you'll face a jurisdictional challenge if either one party decides to skip a step and move on to the next. Kate's spoken about mediation. I've personally seen evidence of remote or virtual mediations working really well in terms of the technology, logistics, and just the parties being able to engage with each other. So I think this is always worth exploring, and particularly maybe identifying the cost sanctions that come where there may be a refusal to mediate without good reason. There's also been quite a few new online sort of pop-up fast-track DR procedures that I've seen springing up. CEDA and the Chartered Institute of Arbitrators have launched their own pandemic business dispute resolution service. which offers various services, including, facilitated contract negotiation and a kind of fast-track arbitration service for disputes below a certain financial threshold with a single arbitrator, with the aim to produce the award within 90 days. We've also seen some success stories, I think, where parties have been able to work together and in a series of sort of coordinated workshops to rebaseline the project and agree a new fixed price, which takes into account the effect of COVID-19 restrictions that are ongoing or likely to occur in the future. But I do think this was possibly easier to achieve in the early days of the pandemic and on projects where there is no pre-existing delay. We've already touched upon this, but as time has gone on, it's certainly been my experience that the industry has, as the industry has adjusted to a new normal, parties are taking more firm positions and digging their heels a little bit more, particularly outside of the public sector. One thing I've seen work really well is in terms of mitigating disputes, and this is a general sense really, but it applies to COVID as well, is the early engagement of experts, where one party has engaged an expert who's produced a really well drafted report, which is then disclosed on a WP basis to the other side. It can be particularly effective, I think, in really complex delay claims where it can be difficult to work out what's on the critical path at any given time. You may have concurrent delay arguments, disagreements about the float, for example. And I think it's quite helpful on two levels, really. One, as a good means of sort of stress testing and managing expectations on the claimant's side, maybe injecting some realism into things if necessary, but also, from the other side of the fence as the defendant, seeing a well put together and well drafted expert report quite early on does really focus the mind and give the impression that the other side's about to run off and commence an adjudication against you. So, it helps to force the other side to take the issue seriously. I think related to this is the importance of both sides really getting to grips with the time and costs impacts of the claim as soon as possible. David mentioned this. It's certainly my experience at the start of the pandemic was just the focus is very much on making sure we're getting the contractual notices in on time, especially where there are condition precedents, reserving rights, making sure you're not waiving anything under the contract. But it can't really stop there. It's then on to, well, how do I now make sure I can properly articulate the basis of the COVID claim? And the reason that's important is that, a global claim where the COVID delay is just simply lumped in with loads of other delayed activities just really won't be taken seriously, particularly if the sums are large. And I think you can end up, and I have seen this quite a few times, where even if the paying party, that they may think there's some entitlement in relation to the COVID impact on the project, but because they can't break it down or interrogate it properly, then the parties just end up in these entrenched positions where the only way they can really resolve things is through formal proceedings. So I think it's important, even for the purposes of settling a dispute, that the claimant is able to prove causation and establish the link between the COVID event that's being relied on and the adverse impact, and to be as specific as possible about that impact. And I think I must say this in every talk I give, and project records are key to this. I will repeat this over and over again. As well as a well-maintained and up-to-date program, which records actual progress and shows the details of all of the disruption, the suspension of the works, and any resequencing. And the SCL and the CLC have produced pretty detailed guidance on the types of records and documents that are required to evidence different types of claims. And I think it going back to sort of the drafting stage, I think again it would be beneficial if the parties list out as far as possible the sorts of documents that they are expected to maintain in the project, and similarly required to produce in support of the claim, because provided that expectations are clear from the outset, that can again help to resolve disputes further down the line. That was all from me, Gerry.
That's fantastic, Amy. Thank you very much, and especially enjoyed the encouragement of the early appointment of experts. That was good. So thank you for that one. Fascinating whirlwind tour of absolutely everything. We've got some really good questions, and so I'll go very quickly as we've got 10 minutes left of our time. So this one is to all the panel, and I'll just read this out. The feeling is that virtual hearings are inferior to in-person hearings. This seems to reflect personal experience though. Is this the correct measure, or should we be measuring whether the outcome would have likely have been different from an in-person or a virtual hearing? So in tandem with this, has the panel got any views on whether one or other leads to a fairer outcome? Anybody want to take that first?
Just helped if I unmuted myself there. I mean, I'm firmly in the camp that in the right circumstances, you get as good a result and experience from a virtual hearing as you do from an in-person hearing for likely a cheaper cost. However, as David and I both said, it is kind of horses for courses, cases for cases. I think we're not far enough into the world of having lots of large cases decided by virtual hearings to be able to say whether actually there's a trend for getting, do you get inferior awards, decision making, etc. I mean, perhaps another impact actually is on the ability of the tribunal members to get together and do their decision making together as well. I mean, there are, I think the cost impact, which is, and when you look at the costs of a case, when you get to the hearing stage, really is a large part, a very distinct proportion of the cases, and that is saved. So I think all of these factors, and unless you have really big problems with internet connections and witnesses not being able to appear, or, I mean, I did a case in November, and when we were in the lockdown in the UK against some of David's colleagues, and we had 8 different time zones in play. We had the witnesses were giving evidence in 2 languages, neither of which was English, although the language of the arbitration was English. People on all these different continents, and it went, although some people did have to get up a bit early and some people did have to work quite late, it worked remarkably well. You got to see these close-ups of everybody's faces when they were giving evidence. You could see the arbitrators' body language much more clearly than I think you can if you're sitting in a room inevitably a bit further away from them. So there was certainly a lot going for it, I thought.
Does anyone else have experience of the virtual hearings or thoughts on
well,
fairness?
Sorry, Gerry. I thought I might just jump in with an alternative view, I guess, from the point of view of an expert having appeared at a virtual hearing. And from my personal point of view, it was the preference would be for virtual hearings because it's less intimidating than an in reality in-person hearing. It felt like you had more time to gather your thoughts as an expert, and perhaps experts would therefore be less prone to being thrown just by not knowing the procedures for the in-person hearing, but also being cross-examined by particularly intense counsel that can actually just have you throw off a perfectly good technical expert. So I don't know if that gives you a better or a worse outcome. I guess it would depend which side you were on and whose expert was yours. But from a personal point of view, the preference was for virtual. But I can see how, from counsel's point of view, the very opposite would be true for the same reasons. So
I was just about to say, I think there's a few members, QCs out there that might disagree with that view.
Yeah.
I think just on the tribunal side, from what I can tell, certainly the courts here, it's a bit more difficult to gauge the views of the arbitration community because that you don't have the same sort of forums in which they give feedback to users. But certainly the commercial court view is that they're very keen to return to in-person hearings, and that they will need some persuasion to hold a hearing virtually. Which I find interesting because that sort of suggests to me that if you're the decision maker, if you like, you sort of want to see the whites of people's eyes.
I would just add to that. It also strikes me that it's quite a subjective topic, really, isn't it? And as common law lawyers, I think we just have a natural preference to, we've placed a lot of reliance on witness testimony and cross-examination, whereas in a perhaps a more civil jurisdiction where it's just less sort of adversarial and more reliance on documents, that they may take a different view.
Okay, I'll move on to the next question. And funnily enough, it's a quantum expert who's asking comments all about money. So I'll just read this out. We all know that disputes are about money, either through pricing risk wrongly, supplier issues, of which there can be many, and unforeseen circumstances, COVID-19 being one of them. Contractors don't have an influence to impact claims in a post-COVID-19 world, as it's an extremely competitive market. Margins are still the driving force of the industry, but clients and lawyers do by shaping the pre-contract process, creating fair and balanced contracts. So what do the panel of lawyers hope to do, if anything, to positively impact claims post-COVID-19? And I know this was answered slightly before you did your talk, Amy. So see if anyone else has any views on that. How can you make things positively impact the claims? Anyone?
I think one of the keys to, in terms of how you handle the claim, I think the key is to handle it proportionately and efficiently. I think some of the developments of the pandemic, I think do allow that. So you don't have people flying needlessly to one-day hearings in London from the Middle East. You can control costs by deploying technology appropriately. So I think it has sort of taught us actually more efficient ways of working. And while I don't think they will fully displace the old ways of doing things, I think they can, combined with the old ways of doing things, make the process a bit more efficient, frankly.
If nobody else gets anything else, I'll jump on to the couple of the last questions, the last couple of minutes. Literally a couple of minutes. Amy, have you seen any government guidance on responsible contractual behaviour having any influence on parties and disputes?
Not really. It's only guidance, so it doesn't have any legal effect. And I think the guidance even says that it's not expressly intended to override specific contractual requirements. So I think much like a duty of good faith, it's very difficult to rely on that to persuade a party to give up a sort of freely negotiated advantage, I would say.
Okay. I think I've got last questions for Helen, particularly. What are the particular challenges of virtual working for the construction industry that makes it likely to affect project quality?
It's a good question, because I think a lot of the focus has been on how do you construct something when you're not allowed on a building site, which obviously I can't, that's very difficult and obvious. But speaking as a designer, I think it's the 3 C's. Construction is, and a lot of people don't appreciate this, it's actually a very creative process. It's also collaborative, and it's also very complex, or can be very complex. So having a true multidisciplinary design team meeting to design anything really is difficult remotely because of the ideas that you've got to grapple with. There's nothing really to replace being in a room, getting out a pencil and drawing some sketches of how you solve a particular design problem. Similarly, not everyone has access to the same technology. BIM being a good example, it might not be proportionate to use BIM on smaller projects, but not everyone has it and not everyone is trained to use it. And then finally, I think I always sound like a dinosaur when I say this, but software will really only get you so far. Rubbish in, rubbish out. If people don't know really what they're doing, trying to use collaborative tools, it's unlikely to help and be far less useful than meeting in person otherwise would be. And the impacts that design decisions can have in construction in particular can be huge, both in terms of the on-site process, construction process, and also the final design. So I think for all of those reasons, virtual working is a particular challenge for construction, for the design process, at least from my point of view.
That's great. And we'll need to finish up there. That's 4 o'clock. So thank you very much to Kate, David, Amy, and Helen. I think everybody's hopefully enjoyed that very interesting and really in-depth look, sometimes through a crystal ball, at what is going to happen in the next few years in relation to COVID. So thank you very much to everybody for joining us, and thanks on behalf of HK and the London International Disputes Week and all the speakers. Thank you very much.
Thanks, everybody.
Thank you.
Thank you.
Bye.